Good afternoon, sir. Sir, am I audible?
Yeah, yes, ma'am.
So, shall we start the session, sir?
Yes, yes, please.
Good afternoon, my dear colleagues. On behalf of Industrial Internet of Things Club, in association with Institution Innovation Council and IPRCL, a warm greetings to all of you. It gives me immense privilege in welcoming all of you to this wonderful webinar on the topic Imperative Elements for Technical Pattern Drafting. It is indeed my great pleasure to welcome our today's resource person, Mr. Arivaragan, corporate lawyer and founder of La Intelligentsia Law Firm, Chennai, to provide the imperative tips for patent drafting. Our resource person has graduated
invention, we can assign it to some bigger industries, and they can able to manufacture, and by that even the organization can get royalty, or the individual can get royalty out of it. So this is a primary benefit. And second one is, there are plenty of awards are available. We are missing all those awards. Many North Indian organizations are getting, the organizations are submitting their students' inventions for plenty of national and international awards. So by that, we can get bigger recognition. And number three, the simplest way, we can add it in resume. Our students are inventing, for the final year project, they are inventing many new inventions. By simply adding this patent application number in their resume, it creates a very big value for them. Easy placement. By simply just assigning it, we can get royalty. Or we have got plenty of case history. One of a student of our company, a student has applied a patent through us. So it's a basic. The basic of that invention is, it's just a navigation system. Many Tamil fishermen are affected by this navigation system. They fail to, I mean, they are crossing the border from our country's border to the next Sri Lankan border, and because of that, many lives are wasted. So this student, his name is Nelson Naveen. He has invented a very fantastic and very simple invention. The navigation system which can be installed in each and every boats, and the fishermen cannot remove it. So if they cross the border, it will automatically inform to the nearby surveillance unit, either a Coast Guard or to the collector office. It will intimate that this boat is crossing the border. And this invention is being purchased by outright. The Andhra government has given a huge sum of money, and they have purchased this invention because they have issue between each and every areas. One area fishermen cannot enter into other areas fishermen. So Andhra government has purchased the invention, and this student has utilized the entire money for his higher studies, and he has even started a company now. So in this way, easily we can able to get our get commercialized. I mean, we can monetize our invention. And number two, one another case history. One of a dental student, he has invented a dental mirror. Normally, if you have visited any dentist, they use a dental mirror. That dental mirror has a very normal invention. He has invented. He is just using a repel technology. Water used to spray in that mirror, dental mirror, and if any blood stains or anything is any obstruction is happening to that mirror, it will just clean that mirror by repelling water into it. So it's a very simple invention, and he has earned almost 45 lakhs from a very big corporate company who has purchased that invention. And he has earned around 45 lakhs for this very simple invention. So there are many other case history where this patent is being utilized in a very effective way. So by this, easily you can able to commercialize your patent, and you can able to get many benefit out of it. So if we say the simple advantages, we can able to get many inventions from our students. And by now, like one another guest has joined with me. One of our senior patent agent, Mr. Sauri Rajan, is with me. So he is going to share you the ways of, I mean, the method of drafting the patent specification. So it's a very complex process. Many students and many inventors fail to get their patent registration because of one reason, that the patent application is not drafted properly. So now I invite Mr. Sauri Rajan to explain few words about drafting a patent.
Good afternoon, sir, and good afternoon, one and all. I request the people to enable me to share my screen on this.
Ma'am, is it possible to share the PPT from our end?
Yes, sir. Yes, I am sharing.
Okay.
I am making Sauri Rajan sir as presenter mode.
Okay.
Okay, thank you. hope my screen is presented.
Say 1 second, sir. Sir, kindly share your screen, sir.
Okay, thank you. Is that my screen is visible to all? May I start, madam?
Yes,
May I start, madam?
sir, kindly proceed, sir. Your screen is visible.
Okay, thank you. Patent drafting. Patent drafting is a part of how to patent an idea and it's a process of writing the invention, description, and claims. It is at the core of every patent application. When the patent is issued or allowed, the draft serves as a specification part of the document. Invention discussion between the patent agent or the patent attorney or the inventor is an essential part of the patent drafting process. It is imperative that the attorneys understand the invention in detail. So all of its claims of usefulness as well as what distinguishes the present invention from similar existing products or process. Because failure in this area increases the chances of application being denied by the patent office. Initially, your patent or attorney has your complete and invention disclosure contract. So this allows you to communicate the information about your invention in enough detail for the attorney to understand the invention. So at this time, your attorney begins drafting the patent application, starting with the claims made about the invention. So we start from the claims portion to draft. So once your attorney precisely captures the scope of the invention in the draft claims, the inventor begins preparing any required drawings to help further explanation in the claims. In some instances, the pictures depict existing inventions to make a proper distinction between those items that is the present invention and the inventions which are all already available in the market or in the public domain, and the invention that you are applying for. So during the patent drafting process, there are many collaborative discussions between applicants or inventors and the attorney. It is not unusual for the scope of the claims to change somewhat during this time. When this time happens, it is likely an effort to further differentiate new invention from existing inventions. Changes could also be related to a new or broader understanding of the invention or its uses. So I want to share the parts of the patent draft. You can see these types of titles in a patent application. First comes the title. Title should be a precise manner and it should be generic. No brand names are allowed like Apple, Samsung, like that. You should not provide the brand name. Instead, what is the present invention? It should be said in a generic manner. Second one is the field of invention. The field of invention is, so for example, I am taking this, it may be a mechanical related inventions, or it is a computer software related inventions, or it may be a biotechnology related invention. What is the represented. Next one is the background of the invention. Here the inventor needs to analyze what are all the other inventions, like the inventions related to our present inventions that are having some disadvantages or drawbacks. So that and all reported in the background of the invention, and what is the need for going to a new invention should be drafted in the background of the invention. And the applicant or the inventor should not write anything about the present invention in the background section. If doing so, your invention may become outdated, because you are not restricted to write anything about your invention in the background section. So next heading is the objectives of the invention. The applicant or the inventors need to write what are all the objections that are all maybe the problems related in the background, or which is already discussed in the background section, need to be said in the objective section. And summary of the invention. It is a collection of paragraphs which is having essential and important embodiments of the invention should be drafted in the summary portion. Next one is the detailed description of the drawings. If your invention is related to a mechanical or automobile or some other inventions, a drawing should be there in order to understand the invention clearly. So you can submit prior art documents that inventions are already available in drawings. So you can, for explanation purpose, you can include those inventions. And you have to write, you have to draw a new diagram which are related to your inventions. And you have to write what all the drawings depicts, that what is the drawing illustrates. So illustration of drawings comes into picture here, which includes a tabulation containing part names and part numbers. So next one is the detailed description of the invention. So detailed description which includes the principal operation of the invention or any scientific methodology to attain the present invention. And the inventor needs to explain what are all the steps that can be taken for arriving at that particular invention. So the detailed description should give you the best method of performing the invention and should clearly mentioning what is the achievement here. So the eighth topic is science portion, which is very essential of the patent application because it gives you the patent right. So if there is a patent, you have to see claim number 1, which is nothing but the invention, so for which the patent is granted. So rest of the claims, claim number 2, 3, 4, 5, 6 are the essential features of the present invention. So abstract is the technical part of the invention. So the applicant or the inventor should give what is the requirement, how you are achieving that. In a simple manner, you have to give abstract with reference of figures, if possible. And drawings. So drawings, the applicants or the inventors need to give drawings which are all line drawings. That is reproducible one. It should not be a picture, or it not should be a photograph of something, or a 3D diagrams, or AutoCAD diagrams, which are all not acceptable by government. So it should be a line drawing. So these are all the essential parts of the patent draft. So if you are taking a patent application, you can see these 10 diagrams. So why a patent professional is required for patent drafting? This is important here. A patent is a legal document, hence the patent must comprise of necessary language and the clauses to ensure that your ideas are protected. Since patent lawyers or agents or attorneys are well versed with the different laws of governing a nation, including patent law, it can prove extremely beneficial to collaborate with such an individual during the patent drafting process. However, before starting disclosing the invention to the professionals, all the inventors or the applicants need to make an agreement called the non-disclosure agreement, NDA, to reveal your invention. Once the NDA is signed between you and your team, you can begin the patent claim drafting process. But you must ensure that your patent lawyer has understood your invention in detail. This means that you have to explain not only the design but also those inventions claims to function along with the factors distinguishing your invention from other similar existing products and processes. So ensuring your legal representative has fully comprehended and the details of the design is crucial. So if they do not, they may not be able to do justice with the patent drafting process, failing which the chances of your patent grant may deny. So therefore, it is recommended that inventors or applicants seek counsel from more experienced patent professionals. So I want to share some of the patent applications granted from our office in order to understand that patent drafting process. So in the Indian patent system, the patent application starts from Form 2. This is title of the invention is a PLC equipped the insect or germ repelling system. So here the applicant and the inventor is Mr. Chellapandian Karthik Rajan. So you can see here the field of the invention is related to an electrical insect germ repelling system. In the background section, the applicant discussed some of the points and some of the inventions which are all related to the germ repelling systems here. Here you can see some of the inventions which are all already there in the market need to be discussed here. So what are all the difficulties in those prior arts that are the existing products? Here he mentions that above all the inventions uses a chemical as a repeller against the insects or mosquitoes, but these inventions cause side effects to humans and environments here. Then what is the requirement and all? Next, the objectives of the invention. You can see what are all the problems in the prior art and how he is taking the objectives and how he is solving. You can see this summary portion, detailed description portion. So here the figure 1, figure 2 illustrate block diagram of the present invention. Figure 3 illustrates the hot air blower containing cold air nozzle arrangement, because he is explaining his invention with these diagrams, which includes part number and part name. Next one is the detailed description of the invention. Here he is explaining what is the drawing, that how it is working, and how he is explaining those things and how he is achieved. So everything is covered here. So what are all the uses of the invention? You can avoid mosquito bites and various diseases caused by mosquitoes. User can avoid harmful insects that may cause skin rashes. Like that he is writing. So after that, science portion comes into picture. So he has invented a programmable logic controller, PLC equipped mosquito repelling system, adaptable for a closed room walk. So what is the structure containing? So A, B, C, D, E are the construction of the invention, below which how it is working. So he claims. And claim number 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. So up to which 12 claims are there. These are granted claims by the patent office. Below that he explains the drawings. This is the block diagram. You can see these are all line drawings. and last is abstract. So like that, the patent application should be drafted in a clear manner in order to understand what is the present invention that is exhibiting the best method of performing the invention. At last, the grant certificate is given. So I want to show you one more patent grant. So I said earlier that Form 2 is the first page, nothing but the title of the invention is 1 pixel, 1 clock throughput modified median adaptive predictor for a BESA DAC encoder. So the applicant name is Mrs. Ramamurthy Jayagauri and Maitri Uday Kumar Kinju Shetty. So the patent application begins from this field of invention background. Here, what is the Video Electronic Standard Association display compression methods, and what are all the inventions which are all already there in the market explains, and what is the invention, summary of the invention, and the detailed description of the invention, which includes here figure 1 to 6. Detailed description of the invention. Diagrams. At last, the patent grant is coming. After filing a patent application, the applicant or inventor is requested to file for an examination request, against which the patent office will give you a first examination report. The first examination report will contain two objections, namely official objections and the technical objections. And the applicant or the inventor is requested to furnish reply to the objections. After that, a hearing will be given. Once the applicant or the inventor heard for the objections which are all not cleared in the FPR, that is first examination report, have to be discussed. Once all the clear, then this patent certificate will come into picture. Your patent application will be getting granted. So, thank you very much for giving me this chance to explain the patent drafting process. If there is any questions, please ask in the comment section. I can give you answers for
Sir, tell us.
Okay.
Sir, so what is the difference between a novelty and an invention?
Okay. The invention, the capability of the invention or the properties of the invention is categorized into 3 sections. That is, if your invention is patentable, then it should satisfy 3 conditions. One is novelty, second one is the inventiveness, third one is the industrial applicability. So novelty is not a separate section. Novelty is nothing but the characteristics of the invention. It should be novel means that particular application is not available in anywhere in the world. Okay. Ms. Vidya Gauri, sir, kindly tell us about the patent registration process. So the patent process, so you are requested to furnish the NDA non-disclosure agreement against which we are taking 2 to 3 days in order to find what is the patentability of the invention, again which the patentability report will be given to the applicant or inventor. If your application, that is your patent application, satisfies these 3 conditions, novelty, inventive step and industrial applicability, then we are going to proceed for a patent application. Once the patent application is filed, then the second process is publication, third process is examination, fourth process is replying to the examination report, fifth one is the hearing. After hearing, the decision will be given to the inventor whether your patent application is granted or not. And what shall we go for English language? So in India, there are 2 languages allowed. One is English, another one is Hindi. If you are filing a patent application in Hindi, you are requested to file a translation of the same. Mr. Dr. K. Mahendran, sir, so tell about design patent. So design patent is different from patent application. So in the US, their act and rules regarding intellectual property like patent or design, they are terming as a design patent. But in our India, it is a design or it should be a patent. So if there is a product, what is the outer appearance of the product? Or what is the exact design? Design should be registered as a design itself. Mr. Madheshwaran M. Sir, how to create drawings for mechanical systems without use of CAD packages? For this, I suggest you to look into the patent applications filed in US. You can understand what is the exact requirement for providing a line drawing without CAD. Mr. K. Mahendran, sir, thank you. Sir, can inventor has claim rights after patent is granted? So this is an important question. I thank Mr. Shanmugam, sir. Here, there are 2 categories comes into picture: applicant and the inventor. Here, applicant who is going to apply for a patent application, and he is the application owner, and the inventor who is inventing the present invention. Both are same person, then he can claim. For example, I can say that Bajaj Auto Limited is the applicant. So the applicant name should be in the company name. So the patent application belongs to a company name. So Bajaj Auto Limited reserves the rights of the patent application, and the people who are all working in the R&D concern, that is research and development people, all comes into picture as inventors. If an applicant who is an individual and he is and himself as an inventor, then he can claim a patent rights. If the applicant and the inventors are not equal, then it is possible that 2 individuals are in the patent application. Then person A is applicant and person B is inventor. Then person B cannot ask a patent right, because patent A is the only person who is the patent application owner. So So who is the application owner? Then patent rights goes to that. It is possible to have patent applications with the plurality of persons, individual persons, or it may be a combination of a corporate firm along with the individuals, and there is no restriction. So he should be a inventor, or it may be a company like that. Thank you, sir. So I thank you for all giving me chance to explain those things. Thank you very much, sir.
Thank you so much, sir, for your wonderful inputs regarding the technical pattern drafting. Arivagan, sir, do you have any inputs for us from your end? Sir? Mr. Saurirajan, sir, is he available? Sir, is he available?
I request, I'm checking, madam. Mr. Shanmugam, sir. So what is the processing time for design patent and product patent? I can say for a design application, from 3 to 6 months, your design application is get granted. And for a product or process of patent application, it may take, if it is an expedited mode of patent application, then it is granted from 6 months to 1 year. If it is a normal patent application process, it may take several years. That is maybe more than 3 hours it may take.
Mr. Arivagan, sir?
Yes, ma'am. Okay.
Sir, your inputs from your end, sir.
Yes, ma'am. So, faculty, thanks for staying till the end of the session. See, patent, as I've already said, patent is a very, very big assert for each and every individual as well as each and every organization. The asserts like cash or money or whatever, like it may be demolished at any time, but our knowledge stays long. So use our creativity properly, use our knowledge properly, and by that we can able to increase the country's wealth as well as our individual's wealth. And for any patent registration support, you can contact us at any time through the connecting faculty. So we are always there to help you and support you for getting your inventions registered. And thanks for the management for giving us an opportunity to give to spread our awareness campaign effectively to all the faculties. Thank you.
Thank you so much, sir. So one last question from our end.
Yes.
What contents do we need to submit for early publication?
For early publication, you need to, yeah, yes, sorry, yes, go ahead.
Okay. What contents do we need to submit for early publication? So if the applicant or the inventor requires, that the patent application should be published yearly. Then he can file for a Form 9. Again, the patent office will publish the document in patent journal every Friday. For this, a Form 9 is required.
Thank you, sir. Thank you so much, Sauri Rajan, sir, for your inputs. On behalf of the organizing team, I extend a really hearty vote of thanks to our both the resource persons, Mr. Arivarajan, sir, and Mr. Sauri Rajan, sir, for sparing their valuable time for us and giving more insights into various things and enlightening our research community. Thank you all for joining with us. Have a nice evening. Thank you, sir. Thank you, Sauri Rajan, sir. Really, it was a very wonderful webinar with
Thank you.
good examples with case study also. Thank you, Arivarajan, sir, for readily accepting the invitation on first call.
Thank you, ma'am. You can support. Thank you.
Sure, sir. Sure. So surely, if we have any clarifications in patent drafting and also in registration process, surely we'll seek guidance from you.